The ADA is turning 30 years old this year, so what better topic to talk with you about than whether or under what circumstances can extended leave be a reasonable accommodation under the ADA. You know the scenario. An employee is not eligible for FMLA leave or has used up all of her leave. So what do you do when the same employee asks for additional time off as a reasonable accommodation under the ADA? This is a question I'm asked by clients as often as any other, in part because it can be frustrating for employers to have to deal with protracted leave and exceedingly difficult to know when enough is enough. First, a quick refresher on the ADA. It applies to employers with 15 or more employees. Some states have statutes that apply to smaller employers, so check your state law. It is applicable to your employees who are qualified individuals with a disability. A qualified individual is a person who can perform the essential functions of their job with or without a reasonable accommodation. It defines disability for purposes of my talk today as a physical or mental impairment that substantially limits one or more major life activities. It defines reasonable accommodation as an employment change or modification that will allow a qualified individual with a disability to perform the essential functions of their job. Reasonable accommodation is pretty much open-ended under the statute, and accommodation only becomes unreasonable when it would pose an undue hardship on the employer. Undue hardship requires consideration of a handful of factors, such as whether it is unusually extensive, substantial or disruptive, or would fundamentally alter the employer's business. This bar is high, unfortunately, in order for an accommodation to be viewed as an undue hardship on the employer. So, with these ADA terms in the background, let's return to the question I posed originally. When does an employee's request for extended leave as a reasonable accommodation of a disability become unduly burdensome for the employer? And why is the answer to this so hard to pin down? In part, it's because the EEOC and federal courts are in disagreement over the relevant standard on this issue, and there's even some measure of disagreement among the federal courts of appeals over how to look at the reasonableness of leave as an accommodation. The EEOC takes the position that an employee is entitled to extended leave if there is no other effective accommodation and the leave will not cause undue hardship. In other words, in the EEOC's view of the world, medical leave of virtually any fixed duration is reasonable, provided that there is a definitive end date and the leave will allow the employee to perform the essential functions of their job at the end of the leave.